Welcome to the Resolution Room. Guys, I'm really excited. We've got 3 guests here today and it's a follow-on from the last episode. So let me go around and introduce everyone. Vanessa Daniel, welcome, mlcoa.
Thank you.
Dr Tim MacDonald, thank you. I'll do some broader introductions. And Andrew Rich, a friend and a partner at Gadens. Thanks for coming.
Thanks, Damien.
This is a collaboration between the Resolution Room and mlcoa, and what we're going to talk about today is ADHD. I spoke in the last episode about the fact that the ABC clearly knew that the Resolution Room was covering off on this topic, so they beat us to it last night on Four Corners. But it was a really interesting conversation. And what we spoke about with Dr Tim MacDonald was the practical diagnosis and the treatment and how it shows up. But today we're going to cover off on a more practical level of how do people navigate it in the workplace? What does it mean in terms of the legal landscape, the regulatory landscape? Vanessa is from mlcoa, so great to be collaborating with you today in this podcast and to talking all things ADHD. It was your idea, in fact. And of course, you're seeing in your work the rise of secondary psychological conditions and how important they are in many compensation schemes, etc. So talk us through, what do you mean by concierge, Vanessa? Do you just help people with bags and show them the rooms, or is there something else that you do?
So we deal mainly with the complex matters and helping people from beginning, just getting some guidance on their matters, what specialists, they might very well need a psychiatrist, or just looking at the landscape of that claim and how they can progress it. So we've got a concierge team that deals from beginning to end, booking, inception. And yeah, that keeps us pretty busy.
That's fantastic. Dr Tim MacDonald, we covered off on your expertise last time. You've got a subspecialty in 3 areas of psychiatry, adult psychiatry, addiction, and consultation and liaison. Talk us through the 3rd category. What does that mean? I haven't come across that.
That's the branch of psychiatry that deals with the people who are medically or surgically unwell. So you would, as the face of psychiatry, be referred a patient who is on a ward, on a hospital. You go and see them, do a consultation, tell the treating team what you think should happen, and then you leave.
So it's part of an multidisciplinary sort of approach to psychiatry. And you're part of the mlcoa team in terms of experts. You were formerly director of Currumbin Clinic, so you've had a leadership role, which we're going to be drawing out some of that because we want to draw on a leader's perspective of managing neurodiversity and ADHD.
Oh, sure. Yeah, I'll speak generally as well as about Currumbin Clinic, which is a great place to work. So I was a director there for the last 3 years almost, and I learnt so much in that time. I was there for 12 years. It's the best job I've ever had. Now I'm semi-retired. I would still very, very happily refer people there. The public service and the private services that I've worked for have been the same and different. I've certainly had to work with a lot of people who have neurodiversity, and I think they just provide different experiences. They give different inputs to a problem.
Yeah, we spoke about that. We spoke about the superpower as well as the downside of the diagnosis. But before we dive a bit deeper, I want to introduce you to Andrew Rich. Now, Andrew is a friend, but he's not here as a mate, just. He's actually a partner at Gadens. What Andrew brings, he's of my vintage as a lawyer, but what he brings, which means his experience, incidentally, but what Andrew brings is a unique perspective because he's been at the bar. He was the national lead of employment at a large plaintiff law firm, and now he's acting and advising employers in this space. And there's a lot that Andrew navigates, not just from a purely legal perspective, understanding the law, but from a risk and more broader strategy perspective when you're acting for employers. So we're really looking forward to hearing your perspective on that. So welcome, Andrew.
Thank you.
So last time we spoke about the diagnosis, we talked about the treatment, and I thought it was really interesting talking to you, Dr. Tim, around the stimulant use as a mainstay, but also some of the lifestyle factors and how important they were. And I guess one of the things we spoke about is some link towards addiction. One thing we didn't cover off is potentially a link towards that and road traffic or other incidents as well.
Yeah, that's an interesting point. That study we were talking about offline I think it was around 15 years ago, showed I think about 1/3 of fatal road traffic accidents may have been due to untreated ADHD. I can't cite that currently, but I will later if you'd like me to. I remember reading a number of articles around that time as well that were talking about treatment of ADHD being something that could potentially prolong the lifespan. It's never really been seen as a disability. There's a very fine line between impulsivity and just being resourceful and responsive to things around you. So, but yeah, they can be involved in more accidents. They can be involved in more drug use, more divorces. It can be more costly.
Yeah, and one of the things that we talked about in Broad Compass was this notion of how, and it's been good. You could add some light on this, Andrew. It's been very much destigmatized, mental health, which is a really positive thing. The downside, that's the upside. The downside might be sometimes an over-identification on a diagnosis, but that's probably a topic for another day. Andrew, we're here to really drill down on the practicalities at a workplace level. And I just want to pick your brain first about the legal landscape. How does the law look at neurodiversity, and how is it to be managed by an employer?
So the law depends a bit upon context and purpose. So some rights that people have, you might have heard about reasonable adjustments and the right to request reasonable adjustments. That kind of concept comes largely from the discrimination legislation. So we've got the Disability Discrimination Act and the anti-discrimination legislation. In that context, what you're looking at is demonstrating that you're suffering from a disability or an incapacity. And so that's the sort of the framework for analysis that the law puts upon the right to access that right, the right to reasonable adjustments. But there is also a broader obligation upon employers under the Work Health and Safety legislation to eliminate psychosocial hazards in the workplace. And that will then extend to an obligation in respect of individuals who have identified as being neurodiverse to eliminate or minimise, as far as is reasonably practicable, the psychosocial hazards for those individuals. And that applies regardless of whether there's been a formal diagnosis or whether there's a disability per se. It's a matter of managing the individual's needs in the context of what they do. So that's the sort of the broad regulatory framework. I guess you've got on one hand disability legislation or anti-discrimination legislation. On the other hand, you've got the Work Health and Safety legislation. And in the middle, there is the Fair Work Act, which kind of takes, broadly speaking, from the anti-discrimination kind of legislation, although there's an aspect of health and safety that sort of is overlaid as well.
So when we're talking about, and even last night when Four Corners was talking about the prevalence of ADHD and the increase in adult diagnosis, what do employers need to know? Is it about a diagnosis or more about a functional capacity, how it plays out and someone presents and does their job?
Yeah, so under the disability discrimination legislation, you don't need to have a diagnosis to start a conversation about what a reasonable adjustment might be. And equally, even though the law is sitting there, there's no reason why, in a practical sense, you can't start that conversation. And it's really about listening. So I think what often happens is that people bring preconceptions to the table. Often things quickly become legal or become overly medicalised. In fact, you can start a conversation before you've got a diagnosis. And I think that's probably often the most healthy way to sort of encourage your employees to feel they can talk to you and to be candid and to then manage that relationship as best you can. Similarly, under the Work Health and Safety legislation, you've got an obligation to consult. So if an employee comes to you and says, it reveals that they've got that they need certain adjustments in their to manage their work, you've got an obligation to consult with them in any event. And you consult with them, you listen to what they want, and that's how you start the consultation process under the legislation. So there's no obligation on that level to obtain a diagnosis. Having said that, from an employer's and an employee's point of view, there may be circumstances where it's appropriate to get a diagnosis. So from an employee's point of view, their capacity to access the rights under the disability discrimination legislation, their capacity to insist upon rights under the Fair Work Act, like there's also a right to request flexible work, for example, those rights all turn upon you giving a diagnosis. Right. Similarly, from an employer's point of view, for them to understand what their obligations might be in respect of reasonable adjustments, they will probably at some point, depending upon how the more informal discussion goes, they will want to send that employee off to get some sort of expert advice about what that employee needs to ensure that they are being accommodated in the workplace and that they are safe to work in the job that they're employed in. So even though you don't have to have a diagnosis, there are circumstances from an employee's and employer's point of view as well where that may be appropriate at some point in the discussion.
That's really interesting. And good point to bring you in, Vanessa, on the diagnosis and the MLCoa line. Are you finding that people are coming to you about employers, for example, about expert evidence on reasonable, well, first of all, the diagnosis and then what constitutes reasonable adjustments?
Yeah, definitely. We're seeing a rise in these type of requests. And if the person involved can provide or perform their inherent requirements of their role, that seems to be a lot of the requests that we get. And sometimes it's at the end of a claim, like someone could have been stood down or on leave for a couple years before they come to us. So I guess some of the reasons for this podcast is to look at, is there better ways that we can do that? Can they, can we reach out to Tim and Andrew earlier? Because it's a long time for people to be stood down or on leave or while we're investigating. I just think there has to be a better way to do it for all of us. We're all here to learn and share insight. And instead of coming to us at the end, are there other steps that they can take in the beginning?
I think it's really interesting what you say about the inherent requirements of the job, because it's, on one hand, it's straightforward for certain sorts of roles. But what I'm finding more and more is that there are people who have management responsibilities. Working out what the inherent requirements of their job are when you're talking about neurodiversity is much more complicated.
Yeah, definitely.
I had a client once who was on the autism spectrum, and he had been very good at his job, and he was promoted therefore to be a manager. But he was a very poor communicator. In fact, really didn't like communicating in certain ways. And so he was effectively then capped at that level by the organisation and unable to move any further forward because there was no capacity in the organisation to understand his needs and to try and adjust their expectations about how managers should communicate with their team to allow him to succeed at that level. So it's quite an interesting, when you're talking about roles, inherent requirements, neurodiversity and the discrimination legislation, it's quite interesting that sort of interplay. I think
it's really nuanced, isn't it? Because one of the things, and very individualized. So when we talk about reasonable adjustments, you need to assess what, as you say, the core requirements are, and how in what way someone is practically impeded. There's no one size fits all for that.
No, absolutely not, because the obligation is to, under the legislation at least, is to make reasonable adjustments to assist the employee to be able to perform the inherent requirements of their job. So it is about that understanding of what the inherent requirements are, so long as it's not going to create unjustifiable hardship on the employer. So it's about then looking at what the job is, what the employer is. So an employer like a large multinational employer versus a small business like yours, the adjustments you might be required to make would be different. And then obviously different employees with different diagnoses, there's different symptoms, will need different things. So it's extremely individualized.
And some employers can't make support the changes too sometimes, or they can't do it within the workplace for the larger ones. Have you seen that?
Certainly. Look, it really depends upon the nature of the employer's business more than anything. The same question arises for people who have physical disabilities and how you accommodate those. But I think in the past, what's happened over time is we always understood work health and safety obligations in respect to physical injuries. That's well understood. The blue-collar workforce and work health and safety managers have been doing that for a long, long time. Then we had sort of bullying was a thing that came up, and everyone started to understand properly what it meant to suffer psychological injury, adjustment disorders, those kinds of things. So we understand that. But the work health and safety obligations also apply to more broadly to psychosocial hazards more broadly as well. And so that's now requiring sort of white collar workforces to think more clearly and in a more nuanced way about what people are actually, what the core of their job is, what they have to be doing their job, and what really can be adjusted. And that's, I think, a challenge for a lot of businesses because they haven't had to look at it in that white collar context before.
In many ways, other industries have been doing this exact thing, haven't they? Like if you look at schools that are holistic, that try to make reasonable adjustments for their students to self-actualise the way they want to. It's already been done in other areas.
And you've seen that trajectory of that. I mean, I know students who, it used to be, if you're going to do an exam, you had to sit down, you had an hour, you had to write it down, and then it was, this student needs, they can take the exam verbally and they can record the answer. But that was really controversial. And so it's been a constant, I think, evolution of people's understanding of what is core to to the task, education and examination or work, etc.
It may be really simple too in some cases. It might just mean that that person needs some fidget time once every few hours or something, you know.
Yeah.
And it would be the same for the workplace.
Well, we covered off on that, didn't we? That like when I was growing up, there were kids who didn't fit into the mainstream of school, the cordial kids, or we'd call them, or something. The hyperactivity was sort of bandied around by parents, but you could just tell they weren't able to comply with the school-based system. But now you're looking more creatively, and it's quite analogous to that, isn't it, in some ways? And I guess that's another point for you, Andrew. I mean, because we look at workplace differently with tech and with COVID now in terms of flexibility, this notion of workplace meaning you have to turn up here at this time, there's a lot more scope, I would have thought, for nuance and argument in terms of this whole area, huh?
Yeah, I mean, in terms of making adjustments and what might be reasonable, as you say, it's sort of working from home. The Fair Work Act also anticipates, in terms of your request for flexible working arrangements when you have a disability, that you can look at different start and finish times, and sometimes people who are neurodivergent work well and focus well at certain times of the day. So those sort of adjustments are almost built into legislation as a sort of right to make that request. The legislation, both the discrimination legislation and the Fair Work Act, also seeks to balance it with businesses' needs, with the needs of the employer. So that's, again, there is still a balance. So it's in the Fair Work Act, it's a right to make the request. Really, it's a right to engage in discussion about reasonable adjustments, but there's always a balance in that discussion. And you see in the cases that often you get the sense, without it being said in the judgments, that where an employee has gone down, if they've tried to request reasonable adjustments and they've lost, you get the sense that there's this other dynamic going on, and the judges may have reached the view that the employee's been a bit unreasonable, and that's why. So there is this, because it is supposed to be a bit of a give and take on both sides.
Yeah.
Which requires also the medical practitioners to be able to engage and not make black and white. You can only work one day a week. You can't work, to be able to sort of recognise, to see what the workplace is and engage properly with the employer about what might be possible. Because sometimes employees fail in these sort of requests when they're so black and white that they can't be accommodated, when sometimes a proper understanding of the possible might enable a more nuanced recommendation from the GP or the medical practitioner.
So they could ultimately use like an OT to do like a worksite assessment or something to get a bit more information about what's happening, and then send it to the GP or to the specialist, or just so they get to know the workplace a bit better and what the tasks are. Because I guess we can see them on paper, but I guess when someone goes on site, it probably gives a lot more clarity and supports the employee a bit better.
And you were referring before about sort of speeding up that process and
Yeah.
not letting someone with ADHD, for example,
sit there for a couple of years.
sit there and get more depressed and more anxious.
We know from the psychiatric injury data, which is more my thing than Andrew in terms of his workplace. I've been a sort of a compensation lawyer. We know that the longer you spend off work, the more entrenched the adversarial view becomes, the more heightened, and that's why in compensation schemes they navigate two sort of extremes. One is about trying to have early intervention to get people back to work, but also to test the reasonable parameters, because people respond, because there's sort of a culpability test in psychiatric. But it's a really fascinating dilemma. On your point, Vanessa, the longer people stay off work, the more problematic it seems to be.
And especially if no one's reaching out to them or making contact, or, what can we do? Is there somebody checking in, even as an employer's responsibility, instead of just letting it go to a medico-legal? I think there's probably other ways. I don't know what you think, Tim, or what you support.
Agree.
Yeah.
There's also the opposite that can occur if you've got the patient that you're treating as a psychiatrist who might have PTSD, for example, from a particular incident or subject to incidents. They're triggered by a phone call from the workplace sometimes, and so shielding them from that as appropriate might be needed.
It can be a tricky line to walk for employers, because they experience both things. They get criticism from both sides. So you sort of you start to it's very hard to get it right sometimes because of that. Which is often why I think things are, employees are sent to doctors very quickly to sort of try and work out for this particular individual what in fact is the recommendation and how they should best manage it. But it doesn't always facilitate a quick return to work, because you've all of a sudden got these people who are sort of outside the process, almost not adversarial, but it's sort of, they've got their own positions. It's sort of positional, I guess, rather than adversarial, and not really, they aren't collaborating really in a genuine way.
Speaking of the balancing act too, well, I've got you, Andrew, what about this issue around the right to privacy, that a person may not feel comfortable disclosing their diagnosis? How do you balance that up?
Firstly, if you are neurodivergent, you're not obliged to reveal that to your employer unless it's going to impact upon your capacity to perform the inherent requirements of your job, in which case you really should, you need to. On the other hand, once someone does disclose to you that they're neurodivergent, let's say, it's their personal health information, and you've got to maintain it sort of confidentially.
Yeah.
So really what that should look like, it should be a discussion with the employee about what you're going to do next,
Right.
who you're going to tell, and kind of why, because you will necessarily, if you're going to do anything about what's been revealed to you, you're going to have to engage others in the process. But it's about ensuring, I think, that there's been an understanding, a joint understanding of what that's going to look like. And also you need to then consider, depending upon the employee's approach to revealing information, can you implement certain changes to work practices? Can you implement certain reasonable adjustments without having to reveal this particular person's circumstances? So it might be, for example, about the way that employees get notice of particular meetings, or the way that the agenda is distributed and when it's distributed, or it might be about certain changes that can be implemented without it being sort of pointed at being one individual employee who this is all about. So it's about considering all of those things and trying to, again, it's a bit of a balance. But strictly speaking, it's health information. It needs to be treated that way.
Right. That's fascinating. And let me talk a bit more about the regulatory landscape, because I'm, like you, thought the workplace health and safety growing up, if you like, and the law was all about physical injuries. And obviously it is, but it played a great role in minimising and reducing some of those risks, clearly. But is there now a regulatory lens that's going to be placed on psychological injuries? Are we seeing any more regulatory activity, potential prosecutions?
Yeah, look, I mean, certainly there is a code of practice in relation to psychosocial hazards that's been around for a couple of years now. But I think that the regulators are much more focused on this issue than they used to be, sort of around the country. I'm finding, and I kind of practice in all the different states. And it seems to be uniform that in each of the different states, the regulators are onto this, so there's the capacity to tell the regulator about an issue in the workplace, and the regulators used to be reasonably unresponsive, I think, to be fair. This is 5-10 years ago.
Yeah, I agree with that.
Now they listen, and it's partly because of the social environment, the political environment, I guess, but also partly because it's now dealt with explicitly in these practice notes. So certainly it's much more on the mind of the regulators.
Yeah, it seems to be. Are you seeing that from your perspective at MLCOA, Vanessa?
We are seeing a lot more cases come through that need guidance and stuff as well. Maybe because in the background there's all these regulatory issues and stuff, or people just they know that the potential could be a common law claim or something has the potential to escalate, or it's been left too late as well too, and just really seeking some guidance from where to go to from here. And that's why I think it's great if we all can, share insights for people to use, or, how they can reach out, or early intervention.
Are they worried about if they have a pre-existing condition of some sort, like some sort of neurodiverse condition, that they will be treated unfairly later on?
Probably. I'd say sometimes with this, they probably haven't disclosed it, and say if it's an older matter and stuff, and then at the end I have seen stuff where it comes back and it's more reference to them having like a disability and stuff as well, but it was probably never disclosed, so they're probably worried about it.
One of the issues that you find in the workplace is that, I think, because as we mentioned before, the way in which the law frames some of people's rights is around disability. There's some stigma around having a disability. And so people may be unwilling, or at least reluctant, to reveal, or either get a diagnosis in the first place, and or once they have one, to reveal it to their employer. And then separately, in some industries, if you're being prescribed medication to deal with your condition, in some industries, the medication you take may be an issue for your job. And so you may also be either reluctant to disclose the diagnosis, the medication, or to take the medication. There are all sorts of things that can flow from all of that, but it's not straightforward. But nonetheless, you can assume, I think, and look, I'm not a medical expert, but from what I gather from the way this is being talked about, is that there is a certain proportion of the workforce who you can probably assume is neurodivergent. So even if you don't know, because no one's explicitly disclosed to you that they are neurodivergent, you can probably assume your workforce has a proportion of neurodivergent people in it. And so then the question is, well, how do you want to deal with that? And you can get on the front foot. You can get advice about it. You can think about the way your policies about the way you manage performance and the way you manage discipline. You can think about the way you run meetings. You can think about the way you design your workplaces. Do you have quiet spaces? If you're open plan, do you allow people to wear headphones? I mean, how do you let people manage their time, their work locations? So you can get on the front foot and get ahead of it without actually having any knowledge explicitly of what's going on in your workplace. And that's you're probably going to be making some correct assumptions about it if you do. And that'll probably lead to you getting more out of those people who are neurodivergent, retaining them in your employment longer. So there are all sorts of benefits. And I think you talked before about not just the negative side of neurodivergence, but the positive side too. If you do it right, then you get to access the positive as well, I think.
Yeah, and it creates trust
Yep.
for employees and workplaces, and that's probably how you maximise people's performance and ability and everything as well, by creating trust.
Yeah, have you seen, Dr. Tim, on that point, various things being structured slightly differently in workplaces, say in the medical arena, to accommodate this neurodiversity?
Yes, but I think it's probably more the people within it that would naturally trend towards the areas that are more appropriate for them.
Yeah, it's self-selecting in a way.
It's a little self-selecting.
Yeah.
You might look at some specialties where there's no patient engagement, for example, and you might have a higher percentage of people on the spectrum that are wanting to study that versus, those that are doing emergency, critical care, the general practice, probably, going to be less
I
on
hear
the
that.
spectrum.
Yeah, that's right. The point that you make is a good one, Andrew, in terms of, say, the psychosocial code. One of the issues it looks to is the level of autonomy as what sort of a factor that now these things aren't prescriptive, they're factors that you can consider. And so, to what extent an employer in a modern workplace can assist someone realistically while still ensuring that the work is done and we get where we need to get is a really good thing to think about.
As I said before, I think it's incumbent upon employers to properly understand what they want from a particular job and a role. So we talk about regional adjustments. It doesn't require employers to create a new job.
Yeah, that's a very important point.
Right? It
can be lost.
Yeah. So it's an adjustment. I mean, ultimately, an employer has a business. It structures it in a particular way, and it's got managerial prerogative to decide, broadly speaking, how it wants to conduct its business, right? So people have to kind of, on one hand, work with that. You can't just say, well, I've got this diagnosis and therefore I want this, and expect that that's just the end of it. Like I said, it's a discussion. But equally, I mean, it does require an employer to properly understand within that job role, what are the key aspects of it. And often I think perhaps COVID made employers think about this more, like how do I monitor this person, make sure they're doing their job?
Yeah. That's right.
What does their job require? How do I manage it?
Yeah.
So that sort of has probably helped a bit, but yeah.
And on that point, when people come across your desk, do you often see it play out in the performance issues? Is that how these things can sometimes surface somewhat late in the day?
Yeah, I think that's probably right. It can do over time, because often there'll be a relationship issue at some point. I think, and then there can be some psychological issues around the way in which a relationship might play out that might lead to underperformance. And then there becomes this question about how you manage a person's performance when they, in response to criticism, say, well, I'm neurodivergent and that's why I'm not performing. And that adds some complexity, let's say.
So I just wonder if practically that's sort of sometimes a sequence that you might.
Certainly, absolutely. Yeah, certainly.
And although I'm struck by the fact that I'm not a workplace lawyer, but I'm struck by the fact that there's no obligation at law to carve out a new job, okay? Mm-hmm. But obviously if someone's highly performing often, isn't it amazing that you'll find that there's much more receptiveness to that concept, even though I'm not saying it exists as a matter of law, but potentially. Just throwing that out there.
Under the workers' compensation legislation, there's this concept of looking for people, help assist them to return to work. So a lot of larger employers are used to looking for other places to place employees when they're recovering from illness. And I guess that's sort of an extension of that broadly. But equally, you need to, from an employer's point of view, the employee has to have an attitude towards engaging with the new role or possibility in order to support it. There has to be, as I said before, it has to work for both sides. So I think that's kind of practically speaking how it probably plays out.
And of course, the other thing that Andrew isn't saying here but wants to say is that there's an underutilisation of mediation in this context, to bring it home, to bring the game together. So just throwing that out there, Andrew. I knew you were almost going to go there.
Absolutely.
Look, if they're not talking to each other too, if there's someone's been stood down or on leave or something for a year or something, and there's no contact, maybe it is.
Look, I certainly agree. I mean, tongue in cheek, you said, I understand, but it's certainly true that I think, as you said before, once you're out of the workplace for a long time, it's hard to come back.
Yeah.
But I think one way of introducing people back into the workforce and back into those relationships that may have been stressful is to have some sort of mediation process, one way or the other, which sort of softens that reintroduction and manages.
It's safe.
That's right,
Safe.
Vanessa.
Because usually that doesn't happen until too late. Usually the mediation process are things that occur once someone's filed a claim. And,
That's right.
and everyone's sort of, that's right.
I'm pleased to say it is being thought about more. I've done 2 in that space actually, and I enjoy it because it's far more creative. It's about, well, obviously, guys, you've been through a pretty extensive disputation process. Where it's all landed ultimately is you've got to find a way to work together. How are we going to do this? And it's very practical, and so it's anyway. So jokes aside, it certainly has its.
If you've got goodwill on both sides, it requires goodwill on both sides. That's not always present.
Yeah,
but you can get goodwill on both sides. There are circumstances where I think mediation is absolutely the right way to go, and to think about then also what's going on, because mediation can be one person on one person. Often it can be about the broader workplace environment that's led to whatever it might be that's caused this particular person not to be able to work in that environment for a short period or whatever.
Yeah, one that came to mind was the reincorporation of a person who'd been off work into a team environment. So it called into play broader team roles and reporting and communication, and it becomes quite specific about, option generation, about how we communicate best. It was really interesting. It was much more creative than some of the other mediation work we're doing when I'm walking the corridor banding around numbers. So it's very interesting. Dr. Tim, is there anything important that you don't think we've discussed?
The emphasis of the diversity as being a strength is probably worth mentioning again.
Yeah.
And sometimes someone with ADHD, you wind them up and point them in the right direction, and they're going to do a lot of work for you in a certain way. Or if they're neurodiverse, they see something differently. You can let them run with it for a while, do a trial period. Sometimes they see things that we don't. Or, I mean, maybe I'm a bit on the spectrum and a bit ADHD myself, and I've done a little bit of unusual research, which I probably wouldn't do if I wasn't on the spectrum.
What are you saying? Just made me think. So we had a recent sort of partners retreat. We did the DISC profile.
I know it well.
So it's not personality based, but it kind of is, and it's a bit of an extension of that. More nuanced understanding of the different ways in which we engage, what we're good at. We worked out some partners are really good at these sorts of things. Some partners respond very well to this kind of, want to do this kind of work and that kind of work. And it's a bit of the same kind of strengths and weaknesses.
Some of my coaching work as well, Andrew, it's really fascinating you should mention that, because people come to you about looking at these issues to address. You flip the script and say, what are your strengths, and are you playing to that? Because often you get more bang for your buck, don't you, in a workplace, if you have a real understanding of what someone's strengths are and they're playing more naturally in that space. Vanessa, anything that we should have talked about but haven't?
I think we got most of it this time. We did well, and good insight and information, and hopefully that can guide the employers a bit more, and would lead them to Andrew and Tim with other questions. Or to us. I think, you've got to have a conversation. I think it's a complex world we live in, and keep the channels open, and there's always a better way, or there's always mediation.
Exactly. Thanks, Vanessa. And now it's obviously a lawyer shouldn't get the final word, but in this instance, we've got to give it to you, Andrew. Anything else from the practical reality?
Look, I think that the key is to have a conversation and to listen at the first instance, and start by listening, I think, and try and leave the baggage or the preconception at the door. Start to listen, and then and make sure and think about your business in the context of really what the key requirements for particular roles are, and just use those two things to see whether you can make things work or not. And before you start to overly medicalise or legalise the situation, if that's possible. Now, sometimes these things don't come out until it's a bit late.
Yeah.
But if you get them early and that's what's happening, then that's a good approach, I think, is to take that approach to it.
It's a good way to end. I'm really proud of the association the Resolution Room has with MLCOA. I'd like to thank you all for your time and expertise. I hope it was really practical. It was intended to. Nothing that's said today constitutes medical or legal advice. This is for general information only. But I certainly appreciate your time, and we'll hope to see you soon. Thank you.
Thanks, Amy.
Thanks,
Thank
Damien.
you.